SJC-13197, Jose Rodriguez v. Massachusetts Parole Board.
Great. Attorney Celli.
May I remove my masks?
Yeah.
Thank you. May it please the court, Melissa Allen Celli for the plaintiff Jose Rodriguez in this case. This case presents many issues, Your Honors, but all of the issues have one thing in common, and that thing is that at every juncture, the parole board has taken the option that involves less transparency. In denying Mr. Rodriguez parole and giving him a 5-year setback, the parole board says that it has implicitly rejected the findings of Mr. Rodriguez's expert on sexual recidivism. The parole board has given no indication why it rejected that opinion. In denying Mr. Rodriguez parole, the parole board says that it implicitly rejected the scientific research that...
Wait, you say they implicitly rejected it?
I think that's...
They said that, or are you saying they implicitly rejected it?
I think that the only possible way that they have addressed it at all, giving them the benefit of the doubt, is an implicit rejection.
So, but they didn't say we are implicitly rejecting. Right, got it.
They just said they considered Dr. Plowd.
That is what they said. They said that they considered Dr. Plowd's opinion, yes.
Plowd, I'm sorry.
Not enough.
I'm sorry?
Why isn't that enough to know that they've considered it?
Well, Your Honors, their governing statute says that they must provide a record of decision that states their reasons for their decision. Just saying that they considered it provides no guidance as to what they did with that consideration. And so I think that they can't just say that they considered it.
So the statute says that they have to give reasons?
In fact, it does. The statute reads, this is General Law, Chapter 127, Section 130. And I think that this is actually something that's misconstrued often, and by the parole board also. They say that it's a summary decision. That's not actually what the statute says. What the statute says is, the record of the board's decision shall contain a summary statement of the case indicating the reasons for the decision. It doesn't say that the decision itself is a summary decision. It does need to provide its reasons for...
Can I ask you, Ms. Joey?
Of course.
Just the bigger picture on this. So this decision was rendered before the deal. Am I wrong on that? Decision came out?
So what happened, the timeline is that in November, the deal decision was argued before this court. And at that time, the parole board made certain representations. 2 months later, the record of decision in this case was issued.
And then deal issues.
And then your decision in deal issued subsequent to that.
Right, that was my understanding. So the question I have is, why isn't this deal? It seems to me when I read your well-written brief, is that you are arguing the deal concurrence, which isn't the law. It's the deal majority that's the law.
So I think there are a few answers to that. First of all, the deal majority decision did not repudiate the deal concurrence. In fact, the deal majority decision does say that the better practice is something akin to.
That's why I started with the parole board didn't have deal. I get the issues, but in fairness, I think if this issued post-deal, there might be an issue, but here they didn't have that guidance. And in deal, the majority really says, hey, the better practice is to spell out these things. And you're right, you've got a 3-page of very short single-spaced opinion to work with, and you're making all sorts of inferences based upon what they say. Same as deal majority, correct?
Yes, though there is a large difference. If you actually go back and read the record of decision in Mr. Deal's case and compare it with the record of decision in this case, and I want to just, I can't state this strongly enough. In November of 2019, the parole board stood in front of this court and said that the one area where it felt like its record of decision in Mr. Deal's case was deficient was in the area of explaining the expert testimony. And then 2 months later, it issued Mr. Rodriguez's decision that gives not more detail about the expert testimony, but actually arguably less detail. And if you look at the records of decision in Mr. Deal's case and Mr. Rodriguez's case, in Mr. Deal's case, the board said things like, the board recommends that Mr. Deal partake in more programming, such as criminal thinking and restorative justice. That is along the lines of what the parole board said that it needed to do at oral argument in the Deal case. It said that it needed to provide some basis that the inmate could use for improving himself before his next parole board hearing. If you contrast that with what is said in Mr. Rodriguez's decision, in the actual decision section, there are 4 sentences. 4 sentences. One says, Mr. Rodriguez has a history of sexual assault cases. That is a static factor that can never change. 2, most notably, he committed the brutal rape of a stranger and then committed 2 serious sexual assaults while on bail. It is also a static risk factor that can never change. 3, he has completed the sex offender treatment program, but only after several failures over the decades. Again, that is a static risk factor that cannot change.
That is static.
Because let me say that the completion of the sex offender treatment program, I think, is arguably a dynamic risk factor that he has rehabilitated himself. But the second part of that sentence where they say that where they focus on his failures, that's something that can never.
His history is all static.
Indeed it is. And then the last sentence is, he has made progress in his rehabilitation, but has yet to demonstrate a level of rehabilitative progress that would make his release compatible with the welfare of society. The entire rest of the decision section is entirely boilerplate. It's the same boilerplate that was discussed in Deal. And if you contrast those 2 decisions, you see that in Mr. Deal's case, there was some reasoning given. There was some consideration given to what Mr. Deal could do to make himself a better candidate for parole the next time around. In this decision, in Mr. Rodriguez's decision, there's nothing analogous to that. They've provided no guidance.
Counsel?
Yes.
I have 2 questions. One, given your recitation of the things in the decision section of the board's decision, is there something in the statute or otherwise that requires substance in a decision section? That is, if something's in the background section, then ergo it wasn't part of the decision? And then my second question is, I'm not quite sure that I now understand your difference between static and dynamic.
So, okay, let me start with the first part of that question. I don't think that everything needs to be said in the decision section.
Okay, so why are you focused on that?
Because what they've said in the prior sections are virtually entirely static risk factors. This is the fear, and the thing that I would like to see alleviated is we can't allow the severity of the offense to overwhelm the parole board's decision when we're talking about a juvenile lifer whose rehabilitative progress needs to be considered.
Well, he's not really a juvenile lifer. He went in, didn't he, at around age 21?
He is incarcerated for an offense that he committed prior to his 18th birthday, and thus he is absolutely a juvenile offender. That is his governing offense in Massachusetts. He stands on no different footing than someone who goes in to prison at 17 years old and commits another crime while incarcerated.
But on the rehabilitative side, is the parole board entitled to take into account his flight to California and his offenses as an adult in California?
Of course they can take that into account to the extent that it bears on his rehabilitation.
That's why I asked as to his rehabilitation.
So as to what weight that can be given in terms of what that means for his rehabilitation, I don't know. But I will say that even this court has held that even very serious offenses cannot form the basis for a life without parole sentence. And the sentencing court cannot say, at sentencing, when they, by the way, know in detail the severity of the offense at hand, that sentencing court cannot say this person is categorically deserving of life without parole. And it's not clear to me what extent the parole board can rely solely on the severity of the offense in determining that this person is not ready for parole.
Can I,
To the second part of Justice Wendland's question, because I thought I had the difference too, but when you talk about whether or not the sex offender treatment was actually satisfied or not here being static, I got a little bit confused for a moment.
I'm sorry, I think that sentence, I would categorize it actually as half static and half dynamic. The fact that he has rehabilitated himself in taking the SOTP, that is a dynamic risk factor. That is something that he has done. However, the fact that he had many failures, or as they characterize it, many failures along the way, now that is something that can't change. You know, we can't, I don't think it is fair to forever deny someone parole because they weren't perfect on their sex offender treatment the very first time around. You know, by definition, progress means that you weren't perfect the first time around.
So is that the difference between dynamic and static?
I think dynamic is something that has happened in the past and is something that can never change. And
Dynamic.
Static
Okay.
is something that has happened in the past and can never change.
Isn't that true of everything that's happened in the past?
I mean, I think in some sense that's, you know, that's not wrong, though, as, you know, to the extent that we're looking at rehabilitation. And to be honest, you know, perhaps it's fair to categorize the sex offender treatment statement as being a dynamic risk factor. The point being, whether it's categorized as a static or a dynamic risk factor is not necessarily that important. The fact is that if they are continually going to deny parole on the basis of the fact that he had some stumbles along the way, but then ultimately did finish the sex offender treatment program, that...
So what do you think a fair amount of time would be between the stumbles and the successful completion? Or do you think they should never consider the stumbles?
No, I don't know. I don't know, Your Honor. And frankly, it's really not my job to figure out how long a time he needs. However, what we
You're
need...
saying that there's...
The parole board decided he needed more time. It is their job, right?
But that is actually not what they said in their decision. And that's the important thing. I am not here to ask this court to dictate what the parole board needs to do. I certainly am not here to dictate what the parole board needs to do. However, we cannot know what the parole board actually did on the basis of this decision.
Can I ask you on that point, just to clarify for me, you criticize the use of the assessment instrument, correct?
Yes,
The risk
I do.
assessment instrument as it relates to juveniles. And that was part of the deal, concurrence at least, that said you should use an assessment tool, which was used in this case. Is that something within the discretion of the parole board, or is it, in your view, something that is inadequate and denies a meaningful right of parole?
So again, if we look to the statute that governs parole board decisions, it's Chapter 127, Section 130, and that statute is what calls for the parole board to use a risk and needs assessment. It is illogical to think that the parole board could use a risk assessment tool and satisfy that statutory requirement if the risk assessment tool itself has no basis, bears no resemblance to the reality of whether or not someone is going to recidivate. So whether or not the parole board can use the
So
LS...
whether it's a valid or invalid risk assessment tool is something that you criticize, but do we have any case law on this? I mean...
We don't, because we don't have any information on this. We have the parole board is opaque on the use of the LSCMI. You know, we don't even get an unredacted copy.
You see the trouble I'm having, because you're basically saying this is a horrible instrument, it's not correlated to juvenile offenders, so just, they can't use it. And I'm trying to look at this and say, well, how do I decide whether or not, I'm not an expert in this area, how do we decide this?
I would argue that I'm not here to say they can never use the LSCMI for juvenile offenders. What I am here to say is that if they're going to use that, they should show why it's valid or how it's valid, which they haven't done, and I don't know whether they can do.
And as far as your overall argument goes, when you talk about static versus non-static factors and the like, the parole board doesn't have any obligation to distinguish between static and non-static, but our job is to see whether or not their opinion, whether or not the decision is constitutional, in that it gives a meaningful right to parole for juvenile offenders. That's what we're here for, correct?
Absolutely, absolutely, and that depends on the inmate's behavior over the course of his life. We cannot allow the seriousness of the offense to play to emotions and govern.
Is that really what's, is that, if you take a step back from this case, whether it's the use of LSCMI or every issue we've talked about, other than the procedural issues and how much support there should be in the decision, and issues of the advanced age. What seems to be driving this, though, is, I understand it's the designated offense is the juvenile offense. What seems to be driving this is that two offenses as an adult. And that's sort of palpable in the whole case, isn't it?
I suppose it is, Your Honor, but if they are relying on those two offenses, all I'm asking for is for them to explain their reasons for denying parole. You're guessing that their reason for denying parole is the basis of these two other offenses in California, or even worse yet, as the parole board has indicated in its briefing, possibly some acquitted conduct that he was unable to describe in a manner that the parole board found to be adequate or sufficient, even though it was acquitted conduct. The parole board's job is not to sit as a sentencing body. Its job is, the sentencing body had the benefit of knowing about those California offenses. The sentencing body had the benefit of knowing about whatever prior conduct the parole board alleges that, by the way, is not present in either the administrative record or to any real detail in the parole file itself. You know, the sentencing body had all of that information at its disposal. It created a sentence on that basis. It is not the parole board's job to sit as a super sentencing court.
And just to get back to our job, can you just explain to us what basis we would use to determine that the board's decision is unconstitutional?
Well, I think you've really nailed the problem here. The board's decision is unconstitutional because it doesn't provide a basis for determining what it made its decision, how it made its decision. You cannot know whether it is constitutional or not because it didn't follow the due process requirements outlined in Diachenko and the legislative mandate of giving its reasons.
Because it's cursory, that's what.
Because it is cursory, that's correct. And I see that my time is up, Your Honors. Thank you very much.
Thank you. Okay, Attorney Bloom.
Good morning, may it please the court. Assistant Attorney General Todd Bloom on behalf of the Massachusetts Parole Board. The board's decision in this case is in compliance with this court's decision in Deal. However, the decision was issued prior to Deal, so the board did not have the benefit of this court's guidance of better practices in the Deal decision. Respectfully, what Deal requires of the board and how it might apply to future decisions is not before this court, and the court to respectfully reserve these questions for a future matter where the board did have the benefit of the court's guidance in the Deal decision.
Counsel, if I could interrupt you on that. Even without Deal, though, you know that if they're going to petition for parole and they get denied, there's some interval that they have to wait before they can reapply. So in order to turn this into something where someone has some real idea of what they can do if they have been denied, forgetting about deal for a minute, just we're denying you, and in preparation for whatever else may come, here's what you could work on, here are what our concerns are. How is a petitioner supposed to be able to do that with this decision?
Well, Your Honor, respectfully, putting aside the reasons why Mr. Rodriguez was denied in this case, on the face of the decision, the board did not say specifically what is required of Mr. Rodriguez besides working towards his full rehabilitation. However, there are reasons for that, Your Honor. The board does not necessarily want to list or state different programs that he can take to complete for an obvious potential problem that might cause in the future, saying, like, you told me that I would do X, Y, and Z. I did those, and I would not get, and I was denied parole. A person can be denied parole even though they've completed many programs, is my understanding. So in this case,
Okay.
Does that run into the constitutional issue of not having a meaningful right to parole if no matter what they do? And we're obviously just talking about juvenile offenders.
Right.
I'm sorry, can you repeat
Does that violate the Chenko?
No, it doesn't, Your Honor, because here the board issued a decision that was in compliance with the Chenko and this court's decision in Deal. So if I may briefly just go back to Deal briefly. This court in Deal affirmed that juvenile homicide offenders are sentenced to a mandatory term of life in prison are entitled to a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. However, the right of a juvenile offender in relation to parole is limited. It is not a guarantee of eventual release or an entitlement to parole release. It means that the board provides this constitutionally guaranteed, meaningful opportunity to obtain release so long as it has given the offender a chance to demonstrate maturity and rehabilitation, and in reaching its decision has considered the Miller factors.
How are we supposed to know, and I guess how is a petitioner supposed to know if the goalposts keep getting moved? That's what I don't understand. I mean, you have a cursory decision like this. I understand that you say you may not want to box, the parole board may not want to box itself in by saying, if you do these 5 things, we'll see you in 5 years and we're going to approve the petition for parole. That's not what I'm saying. If you just lead with the conclusion and say you haven't met the criteria for safe release into the public, great. What does that mean? So in 5 years, it's not going to get any more clear. So how could they have a meaningful chance at parole without getting some kind of specificity as to what the deficiencies are?
Your Honor, it's my understanding from the board that it is also on the plaintiff to take additional programs and to do that on his own. He completed 1 program in this case, but there were many reasons why he was denied parole in this decision, and it's apparent from the
Where
face.
are those set forth?
Yes, Your Honor. So here, there were concerns that led the board to conclude that he had not rehabilitated himself. The first thing, the board was primarily concerned with his history of adult sexual cases. This is the first thing mentioned under the decision in Section 3. They say most notably, and then they mention the adult offenses. This is permissible under Deal. After that, they also state on page 23 of the record that it took him a few times to complete the sex offender treatment program. And he admitted at the review hearing that when he was on parole in California, he used a different name and never disclosed that he was on the run for a rape charge in Massachusetts. Also on
How
page,
do we know that that's part of the decision-making for the board?
Section 2, Your Honor. Because it is the board's position that it is the entire record of decision that shows that they consider the Miller factors in this case.
So if it came into evidence and I summarized it, it's part of my decision-making?
Well, it was also brought on at the hearing, Your Honor, in front of at the parole hearing. So the
Right,
record
if it
can
comes
also,
into evidence and I summarize the evidence, ergo, I made it part of my decision. That's the board's position.
can you repeat that, Your Honor? I'm sorry.
If it comes into evidence and I just summarize the evidence, ergo, it's part of my decision-making. That is, I, as a justice on the SJC, can say it was necessarily part of the board's decision-making that they summarized the evidence.
That is correct, Your Honor.
Okay.
The board was also troubled by the fact that Mr. Rodriguez could not remember the names of some of his victims, which is also in the record, and could not recall the details of some of his offenses. And
So
provide
anything that came in is part of the board's decision-making, so if it came in, it's enough to satisfy the constitutional requirements.
It's our position that the record can supplement the board's summary statement of reasons, Your Honor.
Okay. Can I ask you about the risk assessment?
Yes, Your Honor.
Where is that? How do I know how that works?
Well, okay, so first regarding the LSCMI, Your Honor, the board concedes that it is not specifically designed for juveniles. That is in the record below. There is no detailed information in the record about how the LSCMI is conducted. I would first state that here...
So it could just be a random number generator.
Well, how the score is tallied is in our brief, Your Honor, and we do have a commitment summary here that does show information that was available to Mr. Rodriguez in section 1.
I don't know the algorithm used by the LSCMI, do I? Is that in the record?
I don't believe so, Your Honor. No, it's
And
not.
is that something that's given to the applicant?
It is not. It is proprietary information and confidential.
But was it used by the board in its decision-making?
It was. It is used by the board in every case, including juvenile cases.
All right, and we have no idea how it works.
We do have some idea how it works from the studies that are cited by the appellant. The study that is heavily relied on by Mr. Rodriguez does in that study give details as to how the LSCMI is conducted, and that's pretty much the extent of that in the record in this case.
Okay, so based on those studies, it's the board's position that that's a legitimate risk assessment tool?
Yes. The board has the discretion to use that tool, and it is a tool that was used...
Does the board know how the tool works?
Yes, Your Honor.
Okay, so the board knows, the maker of the risk assessment presumably knows. The only person who has to rely on outside studies is the Parole applicant?
Well, Your Honor, it's our position that in this case, Mr. Rodriguez has enough information from the information provided to him to understand his score. The remainder of the score is confidential and proprietary information.
And why is that?
I'd have to, I can answer your question, Your Honor, but I would have to venture outside the record for that.
No, I don't want you to venture outside the record. This is all that the applicant has.
So I would just briefly state that
How is that not arbitrary?
Sorry, how is what not arbitrary?
The use of a risk assessment tool whose algorithm is entirely unknown, it's proprietary, could be, for example, a random number generator, as far as I know, based on the record. How is that not arbitrary?
Your Honor, the board is conceding that it is not a perfect tool.
No.
And
It need not be perfect. I'll concede that. But if I don't know how it works, studies show that it's not appropriate for juvenile offenders, and you're conceding as such. It was part of the record and ergo part of the decision-making in this case. How do I take from all of those things that I do know and conclude that the decision to rely on it is not arbitrary and capricious and an abuse of discretion?
Well, in this particular case, Your Honor, Mr. Rodriguez, as Justice Wilkins points out, was also charged with other subsequent sex offenses as an adult. So it's not clear that a properly normed assessment would treat him just as a juvenile.
Right, that's
so
the
the
point.
board
It's
used-
not clear.
So the board used a tool in this case that was useful and appropriate to Mr. Rodriguez as an adult sex offender.
How do I know that?
Your Honor, I mean, it is confidential and proprietary information in terms of the specifics of how it is conducted. I
Okay.
can
So
tell,
it could be, as I said, a random number generator for all I know. For all you know.
Your Honor, it's not in the record, I'm sorry.
Okay, I understand.
So it is not, again, it's not a perfect tool, and there,
Well, are there any judicial decisions on this tool outside of this? Are there any, is this tool used in other cases, in other states?
yes, Your Honor, it
And
is.
has it been questioned, its validity, rational basis for this tool? I mean, you're sort of, you're walking into trap doors here if you're not careful.
Your Honor, there are other cases cited in our brief that do explain more about the terms of,
But my question is, are there other cases in other states where they validated the use of this tool for adults as opposed to juveniles?
Your Honor, I don't have that information with me today, but I can get that if the court would like me to give a
That
post-argument
seems to be
letter.
a pretty important, that seems to be a pretty important factor.
There are cases in other states saying that it does weigh both static and dynamic risk factors. And again, there's a case like People versus Misner, which define terms more appropriately that are not in this record.
There's other tools that are proprietary that are used sometimes at trials, but enough information, like whether somebody's malingering, for instance. But there's enough information that's given to the parties that they're able to have some sort of analysis of whether or not there's any logic, any reasoning, any rationale to the result.
That's correct. In this case, the LS...
But here, it doesn't seem that information is forthcoming from the board, from the parole.
I would disagree with that, Your Honor, respectfully. Here, besides the unredacted comments in Section 1 of the LSCMI, it shows that Mr. Rodriguez scored in the medium risk range to reoffend, and then what he received a high score on were criminal history, leisure, and companions, and a low score on education, employment, family, marital, alcohol, drug problems, pro-criminal attitude, and antisocial patterns. So he can tell from this how the score was tallied, what the information is, and there were comments under Section 1 as to
So
what...
he knows the input and the output, but he does not know the algorithm used. And it's your position that that is a rational thing for the board to rely on?
Yes, it's our position that everything after Section 1, Sections 2 through 5, which is the redacted information, is proprietary and confidential information. The board has to redact it under contract. And so that information would not be available to Mr. Rodriguez.
I could just briefly go to another subject. I know that you say that the 10 months it took to make a decision, and that those 10 months are now not available to be able to engage in rehabilitation wasn't raised in this particular case.
Yes, Your Honor.
When you have 5 years in between hearings and 10 months for a decision, isn't that a concern that the inmate is really just completely losing 10 months to be able to respond to the reasons parole's been denied?
Well, Your Honor, here we have a regulation under 120 CMR 30108 that says the board should provide the inmate written notice within 21 calendar days after the decision has been rendered. And in this case, the board did that. They provided him notice within 21 days after their decision. So after the January 29th decision. So there was no violation of the regulations in this case. And respectfully, the 10 months between the hearing and the decision, the allegations by Mr. Rodriguez do not show that he suffered legal prejudice, Your Honor.
But can you just go through that timeline? So he got the decision within 21 days of the hearing? Or
The board sent him within
so it was
21 days
like some
of
sort
the
of
January
interim
20th.
decision and then the summary to follow?
They sent him They sent him,
That's okay.
21 days of the decision, a
I can
copy
put it
of it,
together.
yes.
Thank you, yeah,
yes.
sorry.
Okay, thank you.
Thank you, Your Honor.